Good evening. I would like to call this meeting to order. This is the February 2nd, 2023 Board of Zoning Appeals meeting. It is 5:01. 5:31, I'm sorry. Let's do a roll call. Bob Sanders?
Here.
Ginger Hockenberg?
Here.
Bridget Wilson?
Here.
Jane Polanski? Here. Joanna Gupta? And we have our non-voting members in presence. Sharon Armstrong?
Here.
John Lawless?
Here.
And Martha Burke.
Here.
I believe we have a quorum present. First order of business is a motion to approve the January 4th, 2023 Board of Zoning Appeals meeting and minutes. Do I have a motion?
I'll make a motion to approve the minutes from the Board of Zoning Appeals meeting on January 4th. Second.
Bridget has made the motion and Ginger has seconded. Next order of business, motion to approve the February 6th.
Have to vote.
Oh, we have to vote, yes. All in favor?
Aye.
Aye. Vote pass. Unanimous. Next order of business, motion to approve the February 2nd, 2020 Board of Zoning Appeals meeting agenda. Do I have a motion?
So moved.
Second.
All in favor?
Aye.
Aye. The motion to approve the February 2nd, 2023 Board of Zoning Appeals meeting agenda. Unanimously approved. Passed. At this point in time, we have several items on the meeting here in front of you. If anybody has anything they would like to say, this is a good time to step to the podium, state your name and your address, am I correct? Your state your name, your address, and your concerns, or your comments. The floor is open.
Hi, my name is Carolyn Clark. I'm appearing today as a private citizen, despite the fact I'm on the commission here. And I'd like to speak up in favor of both of these people that are on the agenda today to have their variances and their waivers and their exceptions granted. And I think with the Palafingos, I think since their property was built in 1979 and they aren't allowed to have it grandfathered in, I think that an exception can be made in that regard. And I also take exception to the fact that they filed their variance and their waiver in November, and it's just coming now. I know last month there was a problem with notification, but a question I had asked, when an appeal is made to the appeals board for a variance or a waiver, it's supposed to be before the appeals board. It's what our ordinances say. Appeals to the board, and appeal may be made to the Kingston Springs Board of Appeals. And I could read it all, but the building inspector shall transmit to the board all papers. The board shall fix a reasonable time for hearing of the appeal. Upon hearing, any person or any party may appear in person by the agent. And since that was turned in at the end of, I think, November, there was a hearing on the December 6th, and I don't understand why that didn't get put on that agenda, other than it was removed from the process. And it was removed from the process by the same person who had issued the problems with the variances and with the zoning. So it was removed from the process and put before another entity, the Planning Commission, and asked for their determination. And I find nowhere in our ordinances that say that somebody can remove it and put it before another commission to get their recommendation and then bring it before you with that recommendation. And with the Planning Commission, Palafingos were given no notice that they were even on the agenda, so they had no notice to come and, I guess, make their case before the Planning Commission. So it seems like this process has been shepherded through to reach you, to reach a foregone conclusion. As far as Mr. Sullivan is concerned, I think the problem I have with that was when the violation was issued, it was issued without any substantial evidence. It was, you're in violation, regarding the concrete pad and it reaching the adjacent property. Now, he knows that he should have gotten the permit. He knows he didn't get that in time, and he has offered numerous occasions to pay the permit and pay the penalty. But now it's being said that he is over the variance by 2 feet. And I guess the kicker for me is he owns the adjoining property. So who is the complainant? He didn't complain on himself. His son didn't complain on him. And I just think that a variance should be, an exception should be granted in this case because it's his property. And I think it's a high standard to hold someone to when there is no complainant. There's no one being hurt. There's no one being, there's no precedent being set. How many pieces of adjoining property are going to go over a variance by 2 feet? And this property is going to be in that family for years to come. And thank you for your time.
Thank you. Any other comments from anyone?
Yeah, I'll say a few words if I can get up. For those of you that may not know me, I'm Chuck Slater. I'm a former commissioner. I live at 328 Harborview Trail. I'm the neighbor of the property in question. And since he's moved in, that man has spent a considerable amount of money improving that property, inside and out. So I think this violation is nothing to be concerned about. That's all I have to say.
Addressing the first issue, Ms. Clark, we try very diligently to work with Andy. There is a problem in the fact that there are 3 separate lots. He may own them all. And you correct me if I'm wrong.
Probably need to get to that in the actual hearing on the matter itself.
Would anybody else like to make any comment before we continue and close the comment section?
My name's Doug Winters. I live at 275 East Kingston Springs Road. I live right next door to the 279. That's the variance that Mr. Albert's trying to get. I've been living at that location since 1986. And as far as I know, I've been in and out of that house many times. And in question, they're talking about the basement that he redid without a permit. That basement has been done long ago. And so if it's anybody's fault, it would be the county. Because the house was built in '73. So the county's one that issued the permit, so they should have followed up. And also the state, I don't know how they do how they find out, how much, your taxes are going to be. But right now, it's on the books, it's probably showing around 1,500 something square feet, and Zillow's got it at 3,000 square feet. And I understand that looking at it, y'all guys are losing money, so to speak, because you're not getting the tax revenue off of it. Well, yeah, I take it up to the county. They're the ones that started the mess. But it's true, Rick Alberts, he's doing his best to take a house he bought as is and redid the whole thing just about, but not downstairs. He ain't even touched it downstairs at all. It's still the same way. So anyway, y'all got any questions for me? Okay, thank you. Thank you for your time.
Would anybody else like to render comments? At this time, I'm going to close the community input and concerns session, and we'll move forward. First order of business would be the Andy Sullivan request for a variance. And
If I could jump in here, Madam Chair. You all obviously met last month and had a hearing on this, and we didn't have any parties here. At the time of that hearing, the town was of the understanding that proper notice, as required by the Board of Zoning, by the zoning ordinance, had been given not only to the parties involved, but to all others, neighbors, etc. After the hearing, it was discovered that indeed through an oversight, notice had not gone out. So in the interest of due process, the town of Kingston Springs is asking you as the board to reconsider your decision and to rehear, to afford a full rehearing to not only Mr. Sullivan, but also Ms. Albert and Mr. Palantingle for tonight. So I just want to clarify that a little bit. So you're actually going to be having a vote first as to a motion to allow a rehearing on it, and then you would have a hearing. So these are divided 2 items for each of the 2 cases.
I make a motion that we rehear the orders of business on the Sullivan property tonight, as well as the other property tonight, since we didn't know that there wasn't notice given. That's why we tabled those decisions.
Second.
all in favor?
Aye.
Aye. Motion so passed.
All right, so now you're ready to move into your hearing with respect to Mr. Sullivan.
Okay. Anybody want to make a comment on this?
I believe it may be appropriate to have the
Mr. Sullivan come up and-
applicant to come up
May-
and state his case, and then you'll hear from
Sure.
Tara.
Mr. Sullivan, would you like to step forward and give your name and your address and your comments?
Your address and comment.
Andy Sullivan, 608 Mount Pleasant Road, Kingston Springs. As far as I'm concerned, we stopped this tonight. I've called a lawyer. I'm tired of fighting this. The lawyer will be here the 14th with Judge Maxey. I've been harassed. I'm tired of it. This has been going on over a year. It's sickening. So I'm a hard lawyer. Everything I tried to do, I've been stabbed in the back. I'm not doing it no more. So a lawyer will take care of it. And if I can postpone this to February 14th, I'm asking to do that.
May I address that? So, Mr. Sullivan, this is actually a hearing before
I can't hear
this body.
Come over here. I can't hear you.
Okay, I'm sorry.
Oh, why y'all can't get
Sure.
secret system?
So this body here is its own quasi-judicial board, and so they only meet maybe about once a month or as needed. Your hearing on the 14th is with the municipal court judge, with Judge Maxey. So I guess if you want to ask them to table a hearing before this board until after you meet in Judge Maxey's court next week, I guess you could do that. But this board will not be back in session on the 14th unless they decide that they want to recess to that point in time.
Well, I plan on going further than the concrete pad.
I'm sorry, you plan on,
Mr. Sullivan, can you further explain what your intentions are?
No.
Mr. Sullivan, who's your attorney that will be coming on the 14th?
Do what?
Who is your attorney that's coming on the 14th?
She'll call and talk to him. She destroyed my first attorney by calling him. Admitted to calling him, admitted to the judge that she called him. We talked 3 or 4 times when this first started going. Then I found out that she'd been calling my attorney. He won't answer my calls no more. I've sent him a letter. He won't answer nothing. I don't know what she talked to him for. In my mind, she has no business calling my attorney. You should have called my attorney, not her.
If I can find out who your attorney is that's gonna come in on the 14th, I'll be glad to call that attorney ahead of time. But I'll need to know the name of who it is, so I know who to reach out to.
Shannon Crutcher.
Shannon Crutcher? Okay. Thank you. I'll reach out to Mr. Crutcher. So are you asking the Board of Zoning Appeals to table any decision on your application, or are you gonna
Well, you know, I
withdraw?
can't figure out why, I wasn't notified of the last meeting. I didn't get no letter in the mail, I didn't get nothing on my phone. And the last time we met, Bob talked to you, in my mind, it was 3 of y'all here, I believe. And I thought y'all was gonna make the decision, do I get a variance or not? I was forced to get one. You need to get a variance, you need to get a variance. You had to apply for a variance. I applied for one, paid $150, come down here, and I don't understand what happened the time that we met with you and the other 2 ladies. I don't know what went on, I never did this before. Then all of a sudden I get something at home, you've been denied. I was asked to go and get this variance. It was mentioned to Judge Maxey. He needs to get a variance. I do it, and I got stabbed in the back. I got denied.
Let me clarify something for you. There was a survey that was done for the property lines to help you. We told you at that meeting that you would need to get back in touch with Brian McCain, who did your survey, because he didn't do what was needed for us to allow your pad. So, I don't know if you contacted Brian or not. That's why we deferred and tabled the action to the last meeting, which we didn't know you weren't contacted. So, as a board chairman that night, I resent the fact that you said I stalwarted you. I did not. I gave you options, and apparently you didn't move forward talking to Brian McCain, and I don't know if Sharon talked to him or not. But we were trying to help you. And now it seems as if you're trying to pin this on us, but we were valiantly trying to help you. And I don't know where it fell off the wheels.
It fell off the wheel.
I didn't know that you didn't know about the last meeting
No.
because we had no knowledge that we wondered why nobody was here.
I wasn't notified.
Okay. We didn't know that till tonight. But,
And that's why we've asked for the rehearing, so that he can come back.
so
before-
we've asked for the rehearing. Again, we gave you an option, and that was to get with Brian to explain what was needed. And Sharon could help with that as well.
Well, if she contacted him, wouldn't he have called me?
Because it was your responsibility to call him.
I thought she was gonna do it.
I don't know.
This is,
That was the understanding, was she stated she was gonna get a
Okay.
hold
Yeah,
of,
please.
Please.
Mr. Brian.
I spoke to Mr. McCain, explained to him what the I'm
can you
sorry.
speak up a little bit louder?
So that Andy can hear me. The last time we allowed Andy to approach, 6 months ago, I was Andy without leaves, so I couldn't hear either. Would you like to come closer so you can hear?
Yeah.
I spoke to Mr. McCain. I called him 2 days after the last meeting when Mr. Sullivan was here. Explained to him what the basis of the variance was. The setback for his property is 20 feet. That's the setback for the property at the time of the court was 20 feet. The judge said, can he get a variance? And I said, we have a minimum standard for variance at 10 feet. So if he moves the property line in order to accommodate that, he has no need for a variance. It's simply an adjustment between the 2 lots. And even though it was stated that he owns both properties, he does, but they are separate parcels under the law, which the municipal judge also explained to Mr. Sullivan. So I spoke to Mr. McCain. Mr. McCain, I even asked him on Mr. Sullivan's behalf, because he produced the first survey, if there was a way for him to do it without further charge, since he didn't do what was asked the first time. Mr. McCain indicated to me that he would not do it without charging, although I tried to encourage him to do so, and said he would speak to Mr. Sullivan. And that's where I left it. That's as far as I can go. I can't incur his services on behalf of Mr. Sullivan. So where Mr. Sullivan is in this process is that, like many of the issues that you hear, began without a permit. We worked with municipal court to try to find a path to rectify the slab on the ground, which at the time, Mr. Sullivan expressed he'd like to expand the garage. For the slab for parking purposes, and expanding the garage are two entirely different things in your zoning ordinance. But moving that line and adjusting that line would allow him to keep the slab. Otherwise, it has to be removed because it's over the setback. So that's where we left it. That's where I left it with your surveyor. It's where the municipal court judge left it. He advised him to come here with a survey, and if he couldn't get it within those setbacks, then you had some latitude because of the layout of the property. There's a slope on the side, so it meets the circumstance for that. And that's the advice that he was given. And I'd like to correct something else that was said. I did not call his attorney. His attorney called me.
You told me you talked to him. You told me you called him.
Again.
You said your words, I have spoke with your attorney.
And I did. I said I spoke to your attorney. Mr. Dean represented Mr. Sullivan on the occasion of some litigation between Mr. Sullivan and the city. Mr. Dean called me, asked me what's the issue that he has with regard to the court order that's on file. And I explained that to him. So Mr. Dean's response to me, which I shared completely with Mr. Sullivan the first time I met with him, was that he could not expand to the other property with the business or with the storage of classic cars, because the order was specific to one address, the one in which he resides. So that's where we left it. At this point, there is nothing that the board can do to provide relief for Mr. Sullivan, because we have no document that will allow you to do that plat survey. So he came here at the direction of the judge after conversation with staff, city attorney present, in order to resolve an issue the only way we know how. So the issue is not securing the permit at this point, although he will be required to get one. It's where it sits between the two properties that's the issue.
So, Mr. Sullivan, do you have a new survey? Has the survey been done on your property?
The new one? No. I haven't heard of him. I heard he's not on the board no more, right?
He never was.
He never was on our board.
He was on a regional zoning board.
I know the whole time he surveyed my property, he said, this is a joke. Your property line is more over towards my second lot than it is toward my house.
Well,
And I did not ask for extension on my garage. I've never asked that.
Can I say something?
sure.
I'm his son. The last time we was in the municipal court, the attorney, Mr. Mike, stated that the property line setback was 15 foot. Maxie said, so 15 foot, right? Yes. How far are you over? So we're 13 foot, so we're over 2 foot. And Maxie looked at the attorney and Cozy and said, so 2 foot, can we get a variance on that? Yes. Then we come down here and we got denied because now it's 20 foot again. But in court, it was agreed on 15 foot. So I'm not sure where the miscommunication for so long, it was 20 foot, it got agreed on 15 foot. We were told to come down here to get the variance. We tried to get the variance, it got denied, and then we didn't get any notification to come for the last hearing. So now we're here, and he is a little upset about it because it wouldn't be if something happened and you didn't know it, right?
I completely understand, and the fact that,
I just wanted to clear it a little bit.
and
You did good.
and I would just like to say that I understand your concerns about not being informed about the last meeting. I completely understand where you're coming from. That would be disturbing to me as well. That's why this has been reconvened and revisited. So tonight's meeting is like the first one that's ever happened. And so if we can move forward in that respect, and you guys can get past, well, all this occurred last time. Nothing occurred last time. That's the purpose of tonight's meeting, is to ensure that we get all the facts and all the information. And you know, we may ask some questions, and we're just asking you to provide us with answers. And whether or not we can make a decision tonight, or whether we need to defer it, it will be based upon the information that you can provide to us. And so if we can just continue tonight in that order, that would be awesome. We can do that. Okay.
If I can say one more thing.
Yes, sir.
If this camera does audio, listen, please, you go back to February, December 6th, I believe, when Maxie was here.
He wasn't here.
Well,
not at this
not
meeting.
a year,
He was not at this meeting.
Not a year meeting, but, you know. So we took care of the cars. The car deal's supposed to be done. Can't be brought back up. So he said, okay, what are we gonna do about the pad? That's when the city attorney said, Mr. Sullivan has never applied for a variance. I said, I don't know how to do it. I don't know what to do. She said, talk with John, he'll give you the paper. He gave it to me that night. I filled it out, brought it down the next day, gave it to Doris. Didn't see him, but I gave it to Doris. Then I got something on email, you, prior to the meeting, you need to pay $150. I wrote a $150 check, wrote it down here, put it in a little slot in the door, and I thought that took care of that deal. Well, my point, get back to Judge Maxey, when he asked me about the pad, he said, so we're gonna bring the pad up. He said, 15-foot setback, right? And he looked at her, she said, yeah. And he looked at Mike, and he said, yeah. If it's on that, if they record audio, it's on there. They all three said 15-foot.
I do not have an independent recollection from that date in court. I would be relying upon.
I'm sure Max said.
Are all those meetings, are they taped, John?
Yes, sir. We should have that.
It's on there. I wouldn't lie to Max.
May I make a
What?
suggestion?
Sure.
So, since we have court on the 14th, and since you have hired and since we have court on the 14th, and since you have hired an attorney, for tonight's purposes, because there'd be no way we could get all that audio pulled up and sorted through tonight. So, why don't you ask for this to be tabled to the next Board of Zoning Appeals meeting, which will be after your court date. That will allow me to get with Mr. Crutcher. Let's get everything, let's get all the cards on the table, and let's figure out what we need to do to get the ox out of the ditch and moving forward. Does that sound like a reasonable approach to you?
I think that's the best idea, Andy, and again, we're trying to help you, and I think that's the best way to resolve this.
At this time, we don't have all the information
we don't have-
available.
And that tape
to be
is probably
fair,
very important to you.
that information would be very beneficial for all of us.
Yeah, if it is, I'm 2 foot,
Well, that information is going to help us a
24
lot.
inches.
That'll help.
And,
So
and if I misspoke on the distance, again, I don't have independent recollection. If I misspoke on the distance, I apologize, but we gotta get it right.
Right.
So, let's work with the attorney and let's get before Judge Maxey and see what we can do to get
I
it
think that's business.
handled appropriately within our rules for the city.
And if I may, the zoning district Mr. Sullivan resides in is R1A. The setback on the side is prescribed within the ordinance. That will answer that question as to what the side setback is. That in turn will inform what variance request he needs to make. So, Judge Maxey cannot move forward on his end of this until this is resolved with the property line.
Okay, but the simple solution is to redraw the property line.
That's correct.
And we do need that survey.
And within the
That
property
be
line,
necessary.
I'm gonna move to 2 foot. Or she won't. How far do you want?
Mr. Sullivan.
You don't know how far, you didn't know how far over it was. Y'all rode me big time to have it surveyed. It cost me almost $1,000 to have it surveyed, both lots. I got the receipt where I paid money. pay for $1,075, $975. I bring it down here, lay it on the table, and they jumped all over. I thought they was gonna rip it in half looking at it. And I can remember actually asking you exactly how far over is he? I wasn't really ever sure of it.
That is true. Without a survey, the survey that was provided.
How did you come up with your over on it then?
If I may answer the question, Mr. Sullivan. When Mr. Sullivan poured the slab, there was no permit. There was no plat on record that we could find. The only way to establish where that slab lands was by survey. So when the survey was produced, it's a boundary survey, which has a fairly large tolerance of error. On a 1 acre lot, it should be a much tighter survey, but the judge agreed to accept that. So that boundary survey that was produced showed that the slab that was poured, it was the only way to find out where it was poured, was within the setback and not over the parcel line. I had an original question as to whether or not it straddled the parcel line, because there was no way to determine where it was. And at that point, cars were being stored on both lots in violation of the court order that was issued by the Chancery Court some years ago in this case. The other thing that I heard stated is that there was no complainant. There was. There were several complainants about the property. Some of them live adjacent, some of them live down the road. Usually these calls are anonymous in this case. I don't remember specifically if they gave their name or not, but we don't arbitrarily seek violations. We don't look for them. We respond to complaints. That's how we know what the complaint is. So the solution for this board, until we get a survey that shows exactly where the slab lies, and as the city attorney just shared with the board and with Mr. Sullivan, the zoning ordinance dictates the setback. So the only way to do that, we can review the tape. I was not present at the last hearing because I was not needed. The zoning ordinance will dictate that, and whatever that variance is, he can then request. And he can request that variance based on the slope of the property and where it lies. Or he can adjust the line and bring it current, and he has no variance, which is the preferred methodology for solving that. If he moves the property line to accommodate the slab that's been poured, it resolves the issue completely for the slab. It's a legal slab, and it does not require variance or anything else. So the judge wanted to know if a variance could be granted. Again, because he started without a permit, it's a self-inflicted issue. As we discussed in the last meeting, a variance can't be granted when you start with a violation.
Clarification.
Sir?
How's the permitting process work? He filled out an application, he paid $150. Do you then wait to get a building permit? And what's that time frame? Or is it issued on site?
We're talking about two different things. Mr. Sullivan did not apply for a permit to pour the slab.
Oh, I thought he did.
He
He applied for an application
Hold on.
to come
Go ahead.
here.
I made a phone call that morning asking yes or no question. No details. I called at like 8:15. I said, do I need a permit to pour concrete slab? The lady answered the phone. It wasn't her. She said, I don't know. I said, is this the code? I got the right number? She said, you got the right number. She said, I'll get right back to you. Just very, very soon, I'll get right back to you. 8:15, she called me like 2:30 in the evening.
2:30.
Then she says, I told you this morning. I said, you didn't talk to me this morning. I was in a meeting. So I've been in a meeting for 4, 5, 6, 7 times. Last time she said I was in a class.
I was in a
It
meeting.
was a
with
meeting or
TDOT.
class, they're two different things.
They're not,
And
Mr. Sullivan.
when I called, I didn't go behind the city's back, did I?
Now,
I
Mr.
call-
Sullivan, I have a question for you.
Yes.
Did you have the permit in your hand when the concrete was poured?
No,
So you did not have a permit at the time the concrete was being poured?
no.
Okay.
But
That
I didn't go
answered that
behind their
first
back.
question.
And, well, so she talked about complainers. You talking about complaining about my pad?
There
Who's
are,
gonna complain about my concrete? You can't even see it from the road.
And if I may,
Yeah, please.
I also live in a community, and it's very unusual that neighbors don't get along, but sometimes they just they have issues. And it's, at times, individuals will make a call to the city and say, I have this going on, I'm opposed to it, what do I need to do? And anytime a complaint is lodged, John, correct me if I'm wrong, but anytime a complaint is lodged, it is recorded or
Yes.
or written down as a
Yes,
complaint.
and followed up on.
So we would have all of those complaints, but keep in mind that many of these complaints, if an individual chooses not to give their name and make it anonymous, then that information cannot be let out. However, the information, the person will not be exposed. But that information is still on record, that this has occurred, and and the city has been informed of a complaint by someone. And so, though, because of the anonymity of some of the complaints, the individual property owner doesn't always know. And it could come up as a, oh my gosh, where did this drop out of the sky? And apparently in this situation, that may be the cause for the complaints that you've not heard about, that no one has come to you and directly approached you. They've just gone to another entity and said, hey, I have a complaint, I want to register it.
Can I ask you a question again?
Yes.
Was the complaint on my pad?
The complaint was on your cars, the
They're,
pad.
they're over. We're not talking about the cars, we're talking about concrete pad, right?
Okay, I have a question.
Yes.
I know you called at 8:15 in the morning. At what time, at any point in the day, were you informed that you needed a permit?
2:30. That's roughly 2:30.
So you were informed you needed a permit?
But you had
Yes.
already poured the concrete.
That's right.
And that's why I asked the question, did you pour the concrete before the
Sure.
permit, knowing that you needed a permit?
I didn't know you needed one. Cheatham County, you don't have to have one. I didn't know Kingston Springs you did, but I called. Remember you and I discussed about your screened-in porch.
Well, Mr.
So, I mean,
Mr.
that
Sullivan,
happens. That happens.
I hate
I'm
to
not
be the
bringing him
bearer.
up. Don't bring his court stuff back up, whatever.
I hate to be the bearer of bad news, but to act without full knowledge of what you can do,
But shouldn't you
That was-
get an answer when you call codes?
she
It was
gave
a
you an
yes or
answer and
no.
said she didn't know.
I do
Well,
think you need,
she didn't, somebody else did.
but
Right,
you
right,
you
right,
need
right.
to allow a reasonable period of time to get a response to your
Yes.
inquiry.
Yes.
You know, and to call at 8:15 and pour the same day, that to me is not a reasonable amount of time. Okay?
But, yes, hold on one second here.
Yeah, that's what I was
Okay.
gonna say.
Well, before, I know you didn't mention it, and we had actually talked to a couple builders. Some were building in Kingston, we had talked to builders in Nashville, and I said, all we're wanting to do is just pour a piece of concrete. And I said, all we're wanting to do is put some cars on it, wash cars, because it's all mud. If you go to the house now, I'm driving around, the truck sinks 5 inches in mud. They said, if you're pouring a slab, it's like a sidewalk. They said, I don't see why you'd have to have a permit. So we said, okay, well, that sounds good. Talked to 3 or 4 people. They said, yeah, you shouldn't have to have a permit, just pour concrete slab as long as it's not a structure. I said, okay, that's fine. And then whenever they started putting it in action and started pouring, when he went a step further and said, well, let me just call. When he called, they said, I don't know. Well, that time, it was already got poured and stuff by the time 2:30 came around. So we had multiple builders saying, oh, no. And then I mow a guy's grass, he had a pad poured. I said, oh, how'd you get that poured? He said, we didn't call nobody. He said, the builder come back and poured it.
See, in the city
So
of
we
Kingston
were like,
Springs.
oh, okay, so the builder poured it, we poured a pad, what's the difference? But,
Is this in the city of Kingston Springs?
yes, ma'am, it's in the city.
And
So that's why him too, we were like, oh, okay, that's awesome.
Well,
And-
once again, I think a couple things need to happen here. One, I would advise in the future, moving forward on anything, to have an answer in hand before moving forward on it.
I understand that.
And I also think that we do need the survey, and that way we can make a better decision regarding all the information presented tonight. Is there anything else that
I have a
this board would
question.
ask?
Are we able, if he were to apply for a permit, can we offer him forgiveness?
You
To-
you, as the Board of Zoning Appeals, do not have authority to waive, you don't have the authority to waive the requirement of a building permit. That is not within what's set forth.
So how can he take care of the violation that we can help him?
You
Yes.
can't help him with respect to the permit. He'll have to apply for a permit. Once we get the issue about it being in the setback line, have to apply for the permit to the town. And then the town does have a penalty that it charges for doing work without a permit.
So, but that permit can't be issued without the question of the
Survey.
property line being.
Survey, that's,
Right,
Survey
so it
and the
sounds to me
setbacks.
like that's, we're
We've
right
got-
back
yeah,
to that.
we've got dominoes all lined up. We
So,
just
and-
gotta get the first one
And
to
the two
fall.
things are the survey
yes,
and then the
Property line.
the
property line
being-
changes
correct.
needed to
Don't look
make
like
the
a snake.
pad
Right?
legal.
The pad's still gonna be there. I mean, the pad's still gonna be there, whether you do move the property line, but the pad is still there.
Right, but it's
Well,
within the
the-
variance then.
Yeah.
You won't
Right.
need a variance if you get your property
If you
lines.
line it up and it's on your property, am I correct on this? If you line it up and it's on your property and the property line, when you bring in your survey and it shows that you're over your property line or too close to the setback, if that is the case, then you'll need to deal with that accordingly as what needs to be done to correct that situation. If you are within your boundaries and within that setback range, because of a change on your boundary or whatever, then you won't even need to have a variance. Does that make sense? Because you are your boundaries if that
So
boundary
that'll be,
does change.
if I have to go by the 20 foot, it's gonna be 7 foot over. I'm 13 foot away from the property line right now.
I don't know
The
that.
pad stops here, the property line is 13 foot away. And if the setback is 15 foot, which everybody's telling me it is, except her, then it's 2 foot difference.
Well, we don't know that until we get that survey, and that survey will determine, the decisions that we can make going forward, whether or not a variance needs to be issued or not. The permitting is if it was a whole nother ballgame, that's out of our arena. And so, I would like to recommend that a motion be made to defer this to after the,
I think probably need to get Mr. Sullivan's agreement, or Mr. Sullivan, are you okay if this board defers hearing this and not make a ruling on it tonight to see if we can get everything squared away with the
Yeah.
court next week and with your attorney? So now that motion would be appropriate.
would anybody like to make that motion?
I'll make a motion.
Go ahead.
Well,
Oh,
I have to know this.
Absolutely, please do.
What are you asking for? What you tell Brian? Nobody knows what she asked for, right? What are you asking for?
Mr. Sullivan, at the direction of the court, you need to adjust the property line to fall within the setback so that the slab does not sit in that setback, which is a zoning violation. So that's what I asked Mr. McCain to do. And as you have indicated, he has not responded to me since, and he has not responded to you. I asked him to call you that day. He has not done so. This resolves your issue with this board completely if the line is moved. And if you remember way back 3 or 4 hearings ago in municipal court, that was the suggestion that we offered in court to resolve your problem. From that point, you're done with that. Then the only other thing you need to do is secure a building permit. You'll have to pay a fine. I think it's a minimal building permit of $75 for the accessory use of pouring the pad, which is required. Building code requires that here. There's nothing in the 2015 building code, which this city adopted, that accepts that slab, regardless of whether there's a building on it or not.
There's
It
not
just
gonna be a
does-
building on it.
No, but I'm saying regardless of whether there is a building on it or not, it does not accept that slab because it is a permanent attachment to the ground that sits with an impervious surface. So, that's what you need to do, is secure that survey. And that relieves this board of any need to grant a variance. He just needs to move the line to accommodate the slab and the setback. That's required.
I have a question. So we would have to, if it's 15 foot, we would have to move the line.
I'm sorry. Need to make a public comment because we're in open meetings, so.
For each other.
He was asking a question.
Okay, so we probably need to make sure if that has any
I'm
bearing on
sorry.
this matter, just make
Okay.
sure that that question's verbalized so that we cure any conversation outside, so.
I have a
Yeah,
question.
you have a question.
So, whether it's 20 foot or it's 15 foot. So driveway down, garage, house, driveway down, garage, house, big garage, the pad, and then the lines here. If we move the line, say 2 foot, then if we come down with a paved driveway, because it's gravel, it's hard to get out of, we would have to essentially go down, go over 15 foot, come back, and then come back over. So when we go down driveway, you're gonna run into the corner of the house to get around, if that makes sense. Just while we were trying to figure everything out. And I know at one point we were trying to connect the driveway to make it to where you can go down one and come out, and that was a no-go. But we essentially did want to connect from where the pad is over, connect the driveways up so it would all be paved. But that was a no, and we were trying to figure out why, because if we connected them, I'm like, well, we go to houses every day, but it's in Nashville. We go and there's 4 houses with one road. So we're like, oh, well, maybe we can connect them and then it would be done, but it was a no. So I was just curious if we did that, I would have to come down, and the garage is here to get into the bay. The pavement would go down and then have to go over, and I would have about 10 foot and then come back over 15 foot, if that makes sense.
I'm not an
That's-
engineer, so
well,
I can't,
I'm just
yeah,
trying to.
I can't
I'm just
comment on
curious.
anything that you're
Right.
saying.
Well, I'm just curious, so if it does move over, then if a driveway gets put in, the driveway's gotta be 15 or 20 foot away from setback.
Did the original surveys that
biggest-
he had done on both properties, did that not show us anything like,
It was a boundary survey that showed just the property line and the pad, and that there was the setback, and it showed that a portion of the slab was within the setback of
So-
the lot that Mr. Sullivan owns and resides in. The other lot, Mr. Sullivan owns, his son resides
Right.
in, which is a separate parcel. So it showed it within the setback, which is not zoning ordinance
okay,
prohibits.
so those surveys are valid for our purposes here?
Well, for your
We have the
purpose
one
here,
survey, we don't have the other.
for your consideration of a variance, if a variance was to be considered, and as we've expressed to Mr. Sullivan, he is better off to proceed without a variance than just a property line. But for the purposes of what you have here, no, it's insufficient. It's insufficient in that it does not show the depth of the setback and how far into it it's approached, because it's a boundary survey, it's not required to have that detail. So he was instructed in municipal court to go back and have that done.
What is
showing-
that called? What kind of survey is that called?
It'll be a plat. Right now, what's on submission to the court was the boundary survey. And a boundary survey is a survey that's intended for rural areas, large tracts of land within a town. There's a specific set of rules that state Tennessee puts out for surveys. You have very large tracts, one type of survey, which is a boundary survey. If you have an acre, it's another type of survey. As the lots get smaller, the detail that's required by the state for that plat becomes more stringent, because the land.
But what we're asking for then is a plat
Right,
survey.
which he was asked to produce originally in the municipal court, a plat. But if the property line is moved, in order to answer your question, if the property line is adjusted to accept a slab and it not fall within the setback, then he has no further business before this board. He just pulls a permit for the slab, pays the fine for not pulling the permit, and he's done.
Another thing, at the end of my concrete pad, the property line, where you're asking for 20 foot from the property line.
Again, do we have the zoning book in here?
There's 20 foot of my property I can't even use. It's not mine.
We all have.
We all have
that.
setbacks.
We all have setbacks.
I mean, I've got the same problem in our yard, everybody does.
Everybody
Like
has
the
that.
front of your yard and everything is not all yours.
Those setbacks
And on
are
the
put
side.
there
I
for
know,
specific
it sounds-
reasons, yeah.
What's the difference in, I don't know.
And I
don't know.
understand you own all the property, so
Right.
you're asking the question,
Well-
what's the difference on
Right,
the
well,
setback?
that and the neighbor's got a fence dead on the property line, it's permanent, that's technically a structure, it's got a wall, and it's concreted in the ground. We put concrete on the ground, and then it's chaos, I just don't understand, it's concrete pad, the cars that are on it haven't moved in a month, and either way we go, we both, I have to go from where I'm at to his driveway, so, I mean, I'm not complaining, I'm in the house, I'm not complaining about it, but I don't understand.
Please understand, our role is to simply bring you guys into compliance.
Right.
And in order to do that, if you guys can provide the requested plat survey, then that will help identify where the line needs to be to put you in compliance. And even though you will still have to pay the fines for the permitting aspect of it, it puts you in compliance within your boundaries, which means you are done with any variances and you won't have to take this further in that regard. Does that make sense?
Yeah.
So the property line is really the issue.
Right.
And so if we have that plat map, we can determine where that property line needs to be to get you into compliance.
Okay.
And what we're asking is that you get that, you provide that to Judge Maxey and whoever else, and your folks, your attorneys, and then they'll decide, where that line needs to be. You come back to us, and when that line is defined and you're within your own boundary for your properties, both of them, you know what I'm saying? Okay, that it includes, everything is within the boundary, then, like I said, you are in compliance, and you won't even have to have a variance, which is better off for you in the long run.
Right.
Because if that boundary line is changed, then that will resolve your issue.
Then
Right, and keep in mind too, with respect to the variance, as our planner has reminded me, as she has said tonight, he kind of brought this on himself, so he poured without the permit, so he created the violation, so you guys would likely be without any authority to grant that variance. That's why we're saying, move the boundary line.
Yes, yes. We can't do anything about the permitting, but if you move that boundary line and you come back to us and say the boundary line now says that everything is in compliance with the setbacks, with your boundaries, within your boundaries, everything is correct, it's over, it's done here. Does that make sense? And so that's what we're asking, and that's why we would like to put this off until after you've met with the judge
And to answer the question, we pulled the section, planner pulled the section in the ordinance for R1A, and I think you had handed me section R1. R1A is 20 feet, which is right up.
Mr. Sullivan, to answer that question, and again, I'm going to apologize on behalf of the city for that. I was not at the last hearing, as you know, where it was stated what the setback was for your district. The setback for the district on the side boundary where you live is 20 feet. It's what I said originally, what I
So, if it was agreed on in court, and that's what Maxie agreed on, the attorney and the codes guy,
I don't think that Mr.
that would be something you would bring up in
You're
court.
bringing up with Judge Maxey, they
Yes.
don't have any.
well, I'm just curious.
We don't have that.
So we need to be 20 foot.
The zoning ordinance requires a 20-foot setback.
So
on
20,
side
20,
boundary.
25.
Right.
If
20
your,
feet.
if your lot is zoned R1A, then the zoning ordinance is 20 feet. So, and then I'll address that with Judge Maxey next time
Right,
we
she'll
report
handle
out.
that with your
I will,
attorney.
and with your attorney, obviously, this is what we've got. If we've misspoke in court, I would have a duty to call the judge's attention to what the law says anyway.
The driveway's supposed to be 20 foot apart, concrete.
driveways are separated, and that's something I would have to look out agreements. I don't know it off the top of my head in that particular district, so I could look that up and provide you that answer tomorrow.
I'm not gonna point no fingers, but I know where
Driveways,
two driveways are, hadn't been poured this in a year. They're like 12-foot apart.
again,
And
Mr.
Mr.
Sullivan,
Sullivan, I will say that,
I guess
Right.
nobody's complaining, so nobody's gonna say something.
well, you have that option to
No, I don't
to make
care.
your complaint.
I mind my
Or
own
you-
business.
Or you just let it go, and these issues
Don't
come
bother me.
back, and unfortunately, a lot of times these issues come back when there's a change of property ownership. That's when many of these issues arise, and I don't see that happening in your
They've probably been in there
situation.
50 years.
I was gonna say, I don't see that happening in your situation.
yours, it's.
But
not
when you refer to other properties, that's typically when these things come about.
I don't like the traffic in front of my house, but I don't call down here and complain. Because people have the right to live there. I don't like it. I can run over, try and go to the mailbox. But I don't call down here and complain about traffic.
I completely understand where you're coming from, and it's like I said, it's just, it's the world we live in, and we have to,
You know, back in the old days, they survey property, you go down to the red oak tree or the
Right.
maple, the whatever tree.
Our landmarks have left us.
The landmark,
Yes.
the old stump, you know.
Yes, completely. And
So I don't, you know, I can call, I don't like the idea of this, having that property line moved over. Because it's going to shorten his driveway a lot.
Okay, the only other option you might have, y'all correct me if I'm wrong, is you're gonna have to tear out what's over the setback,
The 2 feet.
which is another option. You make the pad smaller,
But now it's 7 foot. It's not 2 foot anymore, now it's 7.
7 feet, yeah, well, you know, there again,
That,
that was in the conversation, I didn't have anything, but it's clearly in the regs, 20 foot in that district. And you're right, Andy, believe me. I did construction at my house, as you heard me tell. I didn't know you had, I thought as long as you didn't change the perimeter of the building, you could do what you wanted. Well, I had to pay a fine. I didn't know that.
did you take it up?
Huh?
Did you take it up?
No, I paid my fine
How'd you
and
do that?
I came down the road to check.
What we're trying to do.
But your is
I
different.
understand that.
You're going into a setback. I didn't change my building,
Yes.
the footprint,
And we were asked to get a variance for 2 feet.
okay? Well,
And
if
now
you're
it's 20.
asking for the variance based
Well, I
on the
mean, we're
code,
just trying to figure out exactly what. We were asked to come here to get a variance for 2 foot. That 2 foot keeps changing to 7, and it gets changed back, and now it's back to 20. So we're trying to figure out, so the first survey that should have happened, it shouldn't have been the boundary survey.
Should have been a plat.
It should have been a
Right,
plat
that
survey.
should have been stated to us before we were told, hey,
it was.
Well,
No,
hold
it
on,
was
hold
not.
on, keep going.
we were told you need to have your property surveyed. We need to have it surveyed. You need to get your property surveyed. Okay, it's fine. We called, got it surveyed, $1,000 later, boom, here's your survey. That's not good. You asked us to get a survey. Now we need the plat survey. We were never told, we were never specifically told what survey to get. We were told you need to get it surveyed. We got it surveyed, and now the survey's no good. Throw it away. We paid $1,000 for miscommunication. I mean, that's $1,000. That's 3 days of my life at work gone. I can't get those 3 days back. And now it's, well, you should have got this. Well, you didn't get that. This guy was wrong. We were told just to call to get a survey. That's what we did. I mean, I'm not going to lie and sit there and say, oh, yeah, I just need this. I called and said, this is what we need to survey. Get your survey done, no problem. That's awesome. So we got the survey. I took off from work, lost $400 to meet him, to pay him $1,000, so I'm $1,400 out to meet him, and now we need a different survey.
And all I can say to that is, these are matters that this board cannot address. Those will be matters that will be taken up with Judge Maxey and your attorney,
See how that's
and all of that will pan out. I do suggest that the plat survey be done so that they know where your boundaries are and that you can be put into compliance And as Mr. Sanders said, that, you know, there are other options. The other option is to shorten the pad, to bring it into compliance. The bottom line is, there is a boundary line, there is a setback, and whatever is constructed in that area needs to be within those requirements. So if you, I find it in your best interest to meet with the judge on the 14th and then request another meeting with the board. And here's my question. Is that meeting going to be necessary if the plat map is determined that the pad and everything is within his boundary?
Correct.
Will he have to come back before the board?
No, because there won't be,
Okay.
yeah.
So,
What's the
So,
sign
so
gonna
you've
be?
got, so you've got a motion already, a motion and a second to defer this to the next convening of the board, which gives him time, and your attorney and I time to talk, and gives him time to go before Judge Maxey and see if there's any need to come back. And if there is no need to come back, then that can just be pulled and don't have to come back to this board.
Just curiosity, how much is the fine?
For the permit,
Fine.
the fine.
Yeah.
the fine for the permit is double the permit fee. Permit fee is $75 to
Still
start a permit.
$150.
And it'll be $150.
That's what's permit.
Pardon?
That's for the permit and the fine.
And the fine?
Yes.
Yes,
what
that's
she
for
said.
both.
She said the
Both
fine
together.
was
Yes, that is for both together.
$75.
Yes, sir, that's
But that's gonna be later.
that would be the fine and the permit.
But that's
So-
for the building permit.
That's correct.
And that's later after everything else is resolved.
That's correct.
Okay, Mr. Sullivan?
I guess I can't see the point. Moving 20 foot over, the pad's still gonna be there. Legally on paper, yeah, it's 20 foot away. Somebody calls down there, Andy's got a concrete pad down there. Yeah, he's 20 foot away. So they're gonna laugh at that, you know?
But Andy, here's the only other problem with it. And I understand what you're saying, I mean, you know, but we can't set a precedent where anybody and everybody can come down here and say, oh, I'm sorry, I didn't know. We can't set that precedent with the variance because it doesn't affect just your property. Every time in town, it would be like the wild, wild west. I didn't know. You know, you gonna build a house or something? Well, you're gonna have to tear it down. You oversized your, and y'all stop me because I think I'm right. It's, you can't do it for one plot.
I understand that.
Right.
But
Because the next door neighbor owns those plots that it's.
And this is the issue, is that in the deed book, if I looked at your deed, it would say, here's your boundary line. If I looked at your deed, it would say, here's your boundary line. Okay? So, within each of those boundary lines, there are required setbacks. And those are that's the issue in this particular situation, that one of those boundaries, or one of those setbacks is not within the boundary of a particular plat. So, if the plat were to, the lines on the boundary were to move to show that yes, everything is in compliance on your property, leaving everything in compliance in your property, because it doesn't affect your property, right? Okay? Then you're done. Does that make sense?
And I understand that y'all are the same family and you've
Well,
had
both
this,
these properties in my name.
and you've had this forever and you intend to have it forever and forever. And I understand that, but I think too what they're saying is that we have to have it legally compliant because God forbid anything ever happened and you did have to sell one of those pieces of land or something. I'm granted. I know you're saying it's not gonna happen.
I tell you, yes, they will.
But I'm just saying that's the rules. And everybody, they're trying to say everybody has to follow the same rules. And unfortunately, I think it sounds a little silly, but it's the rules that we have to follow. And I mean, I would have to follow the same rules. And it stinks, but it's,
Well, you know, I
The
just
rule.
think a lot, I know these people, they won't be up here too. I'll hook up with my attorney on Monday. I'm still gonna hire him. And I want to talk to him about what they're asking. If he says you might go and call Brian, have it done, if I can get hold of him, I got his number. But I don't know why he didn't do it first. You know, I don't know why they haven't.
That's, I think, I'd like to, we can go around this tree 100 times. We have a motion, it's been seconded.
Who made the
We
motion?
don't have a motion.
I
We don't have a
think we
motion, the
have
motion
a
was
motion.
withdrawn.
My
When you,
mistake,
when you
okay.
said that there was a motion made, I meant to correct you and say that motion was
Yeah,
not
I didn't
made.
think it
Okay,
was
my
made.
apologies, my apologies. So-
Well, is
But we
Mr.
do need a
Sullivan-
motion to be made, if
Mr.
someone would like to
Sullivan,
make a motion.
Mr. Sullivan,
I'll make a motion if we get all voted.
Mr. Sullivan, are you in agreement that we defer this until you get this other stuff done?
Yes, ma'am.
Okay.
Okay. Would someone like to make that motion?
I'd make a motion, we just table this until we reconvene based on whatever's found, if need be.
With regard to a plat survey
Yeah.
and any changes to a property line required.
Yeah. Motion made.
Second.
All in favor?
Aye.
Aye. Mr. Sullivan, we'll defer this until after we have all the sufficient
Can I say
information.
I'm not happy?
Well,
The only other thing we can do is decline it. And then you're gonna have to
Do I
chop
get my
up the
$150
pad.
back?
I can't answer that
I was
question.
asked to apply for it, and I did, I paid $150. It ain't no good.
No, if it's declined and you don't get it, you don't get your money back.
I gotta be twice then, right?
Well, you know, it's like that in everything that you apply.
I appreciate y'all time.
Thank you, Andy.
Go home.
Let it be noted that the motion is unanimous and we'll defer this to the next meeting. Should another meeting be necessary? Okay, moving on. The comment period has been closed for the evening.
Oh, it is.
I apologize.
I just had a question, y'all was talking about Cross Street.
Yes, sir, it's over. We have another order of business this evening, and that is at 279 East Kingston Springs. And it's a variance exception waiver request. Anybody want to make further comment on it before we
And this-
start it?
And you, I believe the motion you had made at the very start of the meeting to rehear, it had both of these matters.
Yes, it did.
Yeah.
Yes, it did.
So that's already been covered,
Okay.
what is
Yes,
on
ma'am.
C. So, so since we've already made that motion, then we're starting over fresh. So just like with Mr. Sullivan, then
Yes.
our applicants would have the opportunity to come in and state their case.
Okay, so at this particular time, do we have anybody who would like to comment on this matter at hand for 279 East Kingston Springs Restaurant?
It would just be the applicants.
The applicant.
Yeah, the
Oh, the applicant, I'm sorry, the applicant only can come up at this time.
Albert or Marina?
Yeah, my name is Albert Parathinga. I live in 270 East Kingston Spring Road. We moved here last May from Illinois, and there is no driveway there, garage there, so we plan to build a garage. So I called a contractor. He lives in Kingston Spring. And he said, oh, your existing driveway and patio there, you need a garage, get a permit for the garage. This one you don't need a permit. And it's in my phone record, he did all this. I'm going to get a permit. No, you don't need it. I did a lot of driveways and garages in Kingston Spring. Not garage, the patios. And he put the cement there, concrete. I applied the permit before that garage. And then Sharon came to my house, oh my God, you did the wrong thing. You didn't get permit. I didn't get permit. It's my fault. I'm sorry. I didn't get it. But contractor, told me do this, Now everything messed up. It's within 10 feet. But my setback pin is my neighbor's house, 3 more feet other side. So maybe I have to, he put the concrete pad, but it's not in 10, maybe 7 feet. 3 feet I had to take it down. That's why I applied for the variance here. Yeah, so something messed up.
Guys, ready? I believe that someone from Mr., and I want to pronounce it correctly.
Albert, just Albert.
Albert, thank you. I think it's Palatino, is that correct?
Palatino.
Palatino. Thank you. Called City Hall and asked if he needed a permit to, for the driveway. The driveway was removed and he wanted to put a new one back. And also asked if he needed a permit for an accessory structure which was proposed as a detached garage. I believe he was informed by the city manager that both those permits were required. And then I think in some conversation with his contractor later, the contractor may have proper opinion that it was not necessary to get the permit. However, the contractor does not adopt or enforce regulations in the town of Kingston Springs. So this originated with a complaint, as they usually do. This one in particular was anonymous. No one gave a name. They just were concerned because construction was going on and they didn't see, it's a small town, there was no permit in the window, which there customarily is when things are built. So at that point, I stopped by, spoke to him. Mr. Palatino, Albert, informed me that he had picked up a driveway permit and an accessory building permit from the city, but they were not completed and had not been turned in. While we were there, I said, well, we're gonna have to stop today because we gotta figure out where we are before we can move forward. So I issued a stop and told him to stop where he was. That was on the 13th. On the 20th, I sat down with Mr. Palatino and his contractor and relayed to them what needed to be done to resolve the issues. While I was there, he said he had the permits in the house, but they were not completed. And would I look at them? So I followed him into the house. I looked at the permits. He had filled out part of it. They weren't complete. They'd never been turned in. Explained to him that he needed to complete those. If he needed assistance with that, we'd be happy to help him. So at that point, what I observed is the driveway was completely removed. And I think there's been a lack of communication or lack of understanding about the expansion of the driveway. The driveway, where it sat before it was taken out, can be put back exactly where it was, because it was there. But the area of the driveway that was expanded to go back to meet the proposed new detached garage has to fall within setbacks because the zoning ordinance was in place when that was done. So he's in a position of having already poured the slab for the detached garage without a permit, and it's sitting on that side boundary line, dead on it. Unfortunately for him, its proposed use is for a detached garage. It can't sit, the building can't sit in the setback. So in the meeting that I had with him and his contractor, I relayed to him and the contractor that that would need to be resolved. There's no variance available because it was done without a permit, without a site plan, with all the things that we usually ask for to advise the applicant. So this board, again, is in the position of not being able to cure that. The contractor indicated in the meeting that day, and I think Mr. Palatino will recall that it would be a relatively easy process to take 10 feet off on one side of that slab and then re-pour 10 feet on the other side. And then when I got back to the office, because this was just a complaint I was responding to, and I started pulling the information from the property. Mr. Palatino purchased a home that was advertised at 3,028 square feet. That was advertised and sold to him. In pulling the property record, as I heard someone say, the only living square footage that's on the property record is 1,500 114 square feet.
Yeah.
So at that point, on the property record, there is a basement that has been finished, but it's not included in the living square footage of the property, which means it was done without a permit. Because if you have a permit, when we process permits here in the city, just as we did Mr. Sanders' permit, that information then goes to the county property assessor, which we're required to send it forward to them so that the square footage can be added for additions or expansions or basements. Now, the other issue that Mr. Palanthingall has is that the uses that he wants to have on his property for accessory, the expanded driveway, they slightly expanded the pad right behind the house. It's a little bigger than it was, the patio space or the turnaround space, right behind the house. Do you know where the concrete is right behind your house?
It goes up
That
to there.
patio, right.
Yeah.
It's a little bit bigger according to what your contractor put on the application. It's a little bit bigger than the one that was there before. He said he just kind of moved it up and connected it a little closer to the house. On property assessor's data, that is a patio. It's not a driveway or a turnaround space, it's a patio. Also done, likely without a pad back in the deck. And I want to address the issue of grandfathering. Grandfathering exists for anything that is constructed before the zoning ordinance goes into place. That is an accurate statement. However, that grandfathering expires if you touch it, other than repair and maintenance for residential structures. There's no insulation under the statute
Because,
for...
the driveway, all the metal thing was popping up, very dangerous to walk.
Right,
So
they corrected a deficiency
Yeah.
in that slab. So if you don't tamper, expand any non-conforming use, our regulations in the city allow that for residential. The state does not insulate for that. We determined in 2006 on another property, working with the planning commission, that that insulation needed to exist for residential properties as well. So had the driveway simply been repaired, not lengthened to meet the slab, the concrete behind the house not been expanded, it would have been a non-issue. You're simply repairing. You get a repair permit, you go on about your business. So now we have a driveway that's been expanded to meet a slab that's sitting in the setback.
You didn't make the driveway yet. Maybe I can avoid that.
Right.
I
we
need a
can
garage only.
Probably alter that.
Oh, okay.
We can probably alter that.
Yeah,
But
yeah.
The layout of the driveway that's proposed is that. The secondary issue that he has is he wants a detached garage of a certain size. He has a deck that's 600 square feet, which he's allowed to keep and maintain and repair. He has 2 storage buildings sitting in the yard of a particular size. So right now, he's over the 50% of accessory use that the zoning ordinance requires. So as the city attorney and I and numerous people have relayed to him, if he submits to an inspection of the finished basement, we can then turn that in as living square footage, which increases the size of his square footage, which then would allow him to have more accessory uses. He would then be at 1,514 square feet of accessory use that he's allowed to have. As it sits right now, the deck on the back of the house and the 2 storage buildings already exceed the 50% that he's allowed to have without having the detached garage or any other proposed use. So that's the issue that he has. We have relayed in multiple conversations next steps. This board, there are 2 variances in front of you, an application for a variance, a waiver, and an exception. As we discussed in the last meeting, and in hearing those, we're going to take them one at a time. One is to waive the permit requirement and fee. This board, as the city attorney stated previously, does not have the authority to waive a permit requirement or a fee. You can recommend to the city commission, which I did in the planning commission meeting the night after I met with Mr. Palanthingall and his contractor, that the planning commission make a recommendation to the city commission to excuse the fine for the basement because he bought it that way. He didn't do it himself. But the only path forward for him to accomplish any of the uses that he wants to have on his property is to add that square footage to this property. So this board, in taking them one at a time, the grandfathering expired the moment that he poured the slab, because that's an expansion of a non-conforming use, which the ordinance does not allow for on residential properties. The waiver of building permits applications, no one has the authority to waive that because it's required by the building code. The third is the exception to not require him to secure a permit for the work inside his house. And as I heard one of his neighbors said, he's invested a ton of money in this property, inside and outside. The day that I was there, there was a gentleman in the yard with a pan with drywall mud and clay.
No,
going in and out of the
no,
house.
he was putting some trim that day.
Right.
It's nothing else.
So he was doing that work there, and there was a statement in the application that I ordered him to stop. I did not. I asked Mr. Palenthal to have him stop so we could see who we were. But in this particular case, the variances that have been requested, the waiver that's been requested, and the exception that's been requested cannot be granted by this board. They are requirements that are outside your purview. The requirement for a building permit. If he wishes to have accessory uses, he will have to submit to an inspection of the basement so we can add it to the square footage and secure a building permit for that. If he wishes to have other additional accessory uses or to conduct work on the inside of his house, that requires a residential building permit. It's required by the building code. Once you adopt that building code, you're required to enforce it. So that's the position that we find ourselves in today. And if I may, with your discretion, I believe the city attorney met or talked to Mr. Palenfingal's attorney yesterday? Or you? Okay. Pardon?
You have succinctly said that.
Okay, so even though Martha Brooks says it's not necessary to go into and delve into that particular part of this discussion, as I have laid out the reasoning why you can't grant what's been requested, because it lies outside the authority and purview of this board.
Then what is his next steps? Because I gotta be quite frank with you. My daughter is 43 years old. She went daycare at that house.
Right.
Yes.
That house has been that way. Here's my problem, and I'm sorry, I'm outspoken, but I do not understand how we, as a city, Ms. Clark, you need to listen to this too, because I know you're active. How do we get these builders and retailers to start paying attention to codes and things? My builder told me I didn't need a permit to do the screen porch. We can't make them do it. They're all in it to make money. So, unfortunately, he was given bad karma. And we have to make a decision that we can't make. I'm going to tell you, something screwed up about this. That's just, I'm being Chuck Slater, but that's the way I feel.
I don't disagree with you. I don't disagree with you, Mr. Sanders, that it is a somewhat frequent occurrence, and as development has become more prevalent, it's a more frequent occurrence that builders, contractors, and sometimes unlicensed contractors are giving advice to applicants. We have done outreach, we posted on the website. In this particular case, Mr. Palenfingal called City Hall and was told that he needed the permits. The other issue surfaced as a result of that complaint. So the steps forward are relatively simple.
Okay?
The steps forward are first, because he desires additional accessory uses, which he can't have right now, it's limited, is to have an inspection of the basement, which the building inspector does. We have done this on dozens of properties over the years. The building inspector does the inspection, finds it to be safe or not safe, and then if there are any issues, he'll let him know for his own safety what those are. Then that square footage is then added so that he now has living square footage that he bought and paid for because of the real estate ad, where he purchased 3,028
28.
square feet, and it's actually 1,514. So that's the first step. It needs to happen because that's going to trigger allowing some of the uses that he wants. For the detached garage, if there were a way to attach it to the house, he wouldn't have the issue, right? He could have the garage attached, but it's detached in the rear and the slab is there. The slab has to be just like Andy. Take part of it out. He has to come into compliance with that. Again, decisions that are made on a case-by-case application apply to every lot within the district. That's what makes them so impactful. So that's his first step, is to submit to that. The building inspector is very courteous. He calls before and asks, when they'll be home so we can go in. He'll go down, do that, measure, do the square footage, and then we'll submit that to the property assessor to correct that record. The second thing that he needs to do is complete the building permit process, which he's filed them, but because of this action, we're stayed until this is over. So he's filed them, will issue them, but he will be required for the work being done on the interior of the house. He's required to have a building permit for that. So he'll need to submit a third permit. Once those are done, I will personally request, as I did at the Planning Commission previously, before this action was filed, I will request they waive the fine for the basement. I can't. Only the city commission can waive the fine for the other two permits, or the other three. I don't have the authority to even request that, because they're required of every other applicant that files within the city. So that's where we are, and I believe this information has been relayed to him. I believe it's been relayed to him again recently, and these are the paths forward. It's not our intent to make it any more burdensome on him than is necessary to cure the violation.
So again, we need to decline the request because we don't have the authority. You've been given the recommendations of what you need to do, and then he won't even have to come back with us.
He will not. All he will need to do is complete the process of filing the permits, submit to an inspection of the basement, so we can determine that it's safe. That will then be added to the square footage of his house. The permits will then be processed like every other permit and issued, and he will have a year. But with the slab, we have to bring things into compliance.
So minimally, he has to cut the slab.
Yes.
So,
We don't,
Mr. Albert, I have one question.
okay.
With all, and again, I haven't seen the layout, but with all that you've got going on, and if you were to go along with what's being recommended here, which you have to, but would you still have the necessity of the two portable buildings? Or could they be torn down, reshoot what you're trying to do with your garage that would fall within the guidelines?
The shed you're talking about?
That's what's been relayed to him. As we sit down, the issue that he has now is he has 700, 800 plus square feet of
Right.
accessory use.
Right.
But the shed is almost falling down very soon.
Right, so
That's
the
a bad
sheds
shape.
themselves, once they go away, because they're on the tax record, that will also relieve the tax that he owes on those if those go away. The deck itself, would it be fair to say it needs some repair? A little
Okay,
bit.
let's see.
Not structurally bad yet, but getting close, because the house was empty for a long time. So that is the subject of the next conversation that needs to occur. What things can we, as the city attorney put it, shave, reshape, bring into compliance so that the uses fall within, if the square footage for the basement is added, he has 1,514 square feet to work with. Does that make sense?
And lot coverage ratios.
I'm sorry.
And lot coverage ratios.
And the lot coverage ratio is another issue for that. Even though he owns a larger piece of property than what's on this particular lot, it has to be on that lot. So if he owns a bigger lot than the house sits on, do you own any property other than the lot the house sits on, or is it all?
No, that's
one
only one
parcel?
lot. It's over an acre.
It's about an acre.
Over an acre, yeah.
So the other requirement, restriction within the zoning ordinance is you can only cover so much of your property with structure, driveway, or impervious surface. And that's limited to, I believe in that district, 30%, but I'd have to check. He's in the R1 district.
Do you want the book?
So I can relay that to him later, but that's a lot coverage issue that also resides within the ordinance. There are two schools of thought of that particular path. I don't know that that ordinance has ever been touched at all since its inception back in the early 80s. It was a state model ordinance for lot coverage. People buy an acre lot. They buy an acre lot or better with the understanding that that lot will not be overcrowded with things because that's the circumstance under which they bought it. When you revise the ordinance to accommodate a particular applicant, when you're outside the state statutes that allow you to benefit one individual, sometimes at the detriment of the other. But the two issues, I think he can fall within the 30%. Because the one thing that does not count towards the 30% lot coverage is the driveway. And the driveway does not count towards that because we require the driveway. So it would be the building, the garage, the deck, the two storage, those things would all come together to form lot coverage, and we include the principal residence. So not the square footage floor by floor, but the perimeter, the outside perimeter is calculated in that as well.
One other question, underneath the deck,
Yes.
is there a concrete slab now?
I don't know, we didn't get that far, I think, underneath the deck.
So that, and again, excuse me for being a novice at that, but with there being a slab already there that the deck sits on.
Oh, no, that's not the slab that we're talking about.
I know, but I'm talking about when you're talking about
Accessory.
the amount of
Calculation.
coverage, that's part of the house, I would think.
The deck itself is an accessory use, right? So it's calculated, the zoning ordinance limits the amount of accessory use. So if you have a deck, regardless if it's attached to your house or not, it's not living square footage, and that's the basis for calculating the square footage he can have as an accessory use. It's the primary
Now, my
residence
question
only.
is, if the pad already exists, and there is a deck on top of that pad, is this being looked upon as two separate accessories
No.
or one?
And that's what I was trying to answer Mr. Sanders' question. I guess I wasn't doing it very well. If there's concrete under his deck, it's only calculated as the square footage of the deck. What we're talking about is a space behind the patio doors, separate from the deck, that existed as a patio.
Different location?
Different location.
Thank you,
Right,
okay, that
yeah.
clarified that.
That's
Thank
what
you.
I was trying to figure out.
We try to be as rational as we can in our calculations of this because everybody wants to use their property as much as they can. So we don't calculate the driveway as part of that unless you expand it and it becomes a parking pad, which is a totally different animal than the driveway. So again, there's a way for him to have some of the uses that he wants. The slab itself for the proposed detached garage, just not in that setback. And that's why I was somewhat surprised that it was done after he had asked if he needed a permit, because the accessory permit tells you what the setbacks are.
Well, my question on all of this is, this was brought before this board, and it appears that this is not the board's concern, that it belongs in another commission, maybe the planning commission. And so I'm asking, do we need to
Yes.
do anything, what do we need to do in this situation?
Two things. One of the filings contained a challenge to my decision to require a building permit.
Really?
Yes, sir. So that was within some of it for the residential, the work inside the residence, which I think Mr. Palatino and I can agree was occurring when I was there that day. So I don't have any latitude with requiring a building permit. The building code dictates, the zoning ordinance dictates that we require one. So that came as a challenge to the decision that I made to require him to have a building permit. That was one of the things. So secondarily, there was a request for a variance, a waiver, and exception, none of which fall within the purview of this board.
So our only issue is the building permit.
That is correct. There are 3 building permits that will be required to bring this property in compliance. The first being driveway, second being, which he has filed, accessory, which he has filed, and for the interior work and the basement, in order to make that a legitimate space to add to his square footage, in order for him to have more accessory uses, that building permit will be required.
Okay. So from these building permits, should these building permits be approved, it would put him over his square footage. But if we do not approve the building permit, am I correct on this?
We don't
You
approve
don't-
of building.
We're not approving the building
You're not
permit.
So
approving-
with what's before you tonight, with respect to whether or not she was right in making him get building permits.
Okay.
The town's position would be is that you would need to deny that request of the applicant, citing that she was correct in requiring permits, and you all do not have the ability to waive the requirements of building permits. And then with respect to the variances requested, the town's position is that you all would need to deny that for lack of authority to grant those, or lack of basis to grant those.
So who has the authority?
So for the variance that is requested with respect to the concrete slab, the only way that you are, and I'm talking about the part that's in the setback lines, I'm not talking about expanding it, the part that's in the setback lines. The only way this board could do that is if either, number one, the situation had not been created by you without a permit, and number two, your lot was so irregular or had such a slope or whatever that to comply with the town's requirements of setback line would be impossible because of the nature of that lot. And so the town's position is you don't have any of those present, any of those factors present, and he poured the slab prior to the permit. With respect to the expansion of the use, allowing you to extend the non-conforming driveway, you do not have the authority to do that either, because your ordinance says you can be grandfathered in. We can't make you take it out if it was already there, or if you want to pull it out and repair it exactly like it was, you can do that, but you can't lengthen it or expand it or anything like that.
But
They
if-
do not have the
If I
authority.
don't remove it, we're going to get hurt, then who is responsible?
I'm sorry?
If you don't take the damaged driveway out, we're going to get hurt when we walk. So who is responsible for that? Me or the
Are
other?
you talking about the fact that you pulled the driveway out?
Yeah, because it was, all the metal thing was popping up. It was dangerous.
You
Like,
can fix it back like to the dimensions that it was. The town.
it was at
is
20
fine.
feet wide before, now bring it to 12. The contract
If you
said,
want
this
to
was,
make it
a s-
smaller, you're.
it's making smaller now because before it was a school going on there, it was a big driveway, wider. Why we need that big? We are more than, sometimes slippery, it waste of money to waste too much concrete.
And that's fine. If you, I
Yeah,
mean,
yeah.
if you have something that has already been pulled prior to, or already been poured prior to the enactment of the zoning ordinance,
Mhm.
you have the right as a grandfathered structure to build that back to the dimensions that it was. If you don't want to build it that big,
Big,
if you
yeah.
want to back it off and make it smaller, town has no objection to that. So that's not a
Oh,
problem.
okay.
But you have to at least pull the permit to be able
That's
to
a
build it
contractor,
back.
then
It's-
he's,
And then Mr. Palatino, where the driveway went past the patio that was behind the house, where that was laid out, remember, we discussed it that day because you had fender boards. The contractor had put the forms in for the driveway. When you expanded the length of that back to the slab, that created a lengthening of the driveway. It has to stay within the square footage that was already there. So by narrowing it now, you can then lengthen it once that slab gets within the setback on the side.
What happened if I don't need a driveway, I don't need detached garage, what happened if I build a garage into my patio? I don't need a detached garage, I don't need a driveway. I have a patio there, I'm going to put the garage there. Is
You
it,
can put the garage, as long as it falls within the rear setback,
yeah, plenty of,
side setback.
yeah, plenty of room there.
As long as it falls.
Plenty of room
within
there,
that.
plenty of room.
And then the portion of the slab that's been poured, that falls, just like Mr. Sullivan, who was here before you tonight, the portion that falls within the setback has to be removed.
That's plenty of room there. That'd be easier then.
So
Keep in mind,
we understand.
Yeah.
accessories that are on your lot.
Yeah, I don't know, it's a less square footage, you know.
So the only motion before this board, from my perspective, and I think the city attorney agrees, is that there was a challenge to my requirements for building permit.
And to deny the request for variance for lots.
And to deny the request for the other variance exceptions and waivers, because you don't have the authority to do so.
And keep in mind that when you make a motion, if you choose to deny, when you make a motion to deny, you need to state with specificity why you are denying it.
And the first one again is, I have the one to, for the request of the variance and the waiver. Very first is,
Right, so you can take them whatever order. If you want that one to be the first one, that's fine. That if your preference is to make a motion to deny the request for variance and waiver of fees based on the fact that you all do not have authority to do so. And also, then the next motion would be, sorry, in the lack of factors that would allow you to do a variance. We've got a couple of different factors that
Right.
weigh in onto that. And then you would also make a motion to deny his appeal of the inspector's decision with respect to the building permits because you don't have authority to waive building permits.
I see. Okay.
And I'm sorry, city planners reminded me that there was also a request for a variance to allow a concrete slab to be poured without a permit, that was contained on the application. You don't have the right to waive the requirements of the permits.
So our motion last time covers everything that's gonna cover this time. So we can just restate that.
Pull that back up, refresh my memory just to make sure.
Okay.
Yes, yeah, that would be your motion. That would combine them all into one, it would make it a lot easier.
It really would, if we could just make
Yes.
one motion out of all
So-
three of them, that'd be
Yes,
great.
yes, if you
Okay,
choose
so I
to do
would-
that, that would address everything
order,
that's in
please.
the application.
So with the understanding that the remedies have been provided to the claimants, I move that we decline the application for variance, the exception, and the fee waiver and other requests as contained in the original application due to a lack of authority by this board to grant such relief request
And the amended application.
and the amended application.
There you go.
Do I have a second on that motion?
A second.
Bob Tim, just a second. All in favor?
Aye.
Aye. Unanimous? Motion is passed.
New business. New business. New business.
That was our new business. Do we have,
Make a motion.
we don't
to
have
adjourn.
any more business tonight. I believe that was our new business. I make a Motion
To adjourn.
to adjourn, do I have a second?
Second.
I'd miss it.
This motion is adjourned, this meeting is adjourned.